Hello, and welcome to Arden Wood Online. I'm John Mitchell, and I serve as Executive Director and CEO. Today's presentation is the first of 3 webinars focusing on key aspects of estate planning. It's not always an easy subject to talk about, but it is absolutely essential to do it. As the saying goes, if you don't have a plan, the state where you pass away has a plan for you. In other words, if you don't plan where your valuables and savings go, the state will claim an unreasonable amount through unnecessary taxation. No one wants that. I suspect we've all witnessed the disastrous effects of not planning. I would love to know how many of you have been to Arden Wood recently or ever. You can get a good feel for Arden Wood from our website, ardenwood.org. Very soon you'll see a complete refresh of the existing website, so check back soon. Our site is a good place to find out about and register for upcoming events, and we have a bunch of them. After the 3 estate planning webinars this month, there's a Bible talk on Saturday, November 7th at 10 a.m., and then 2 webinars on Medicare in the middle of November. The final event of this fall is one of our finest traditions, the annual Arden Wood Christmas celebration on December 6th at 2 p.m. And once again, all of these times are in Pacific time. We're looking forward to sharing a wonderful musical program with you for the first time entirely online. We hope you'll begin your Christmas season with us. Arden Wood is a 501c3 nonprofit organization, and we wouldn't be here today without the loving generosity of countless Christian Scientists since 1930, when we first opened. Donations account for nearly 35% of our operating budget, which supports our Christian Science Nurses Training Program and our Christian Science Nursing Services, including skilled care, sheltered care, also known as assisted living, and our visiting Christian Science Nursing Service all over the greater San Francisco Bay Area. In other news, I'm very pleased to say that we have been able to fully function throughout the pandemic, and we remain COVID-free. We have patients, sheltered care guests, and independent living residents here actively praying for healing and peace on a local, national, and global level. With great wisdom and alertness, we've also been able to make home visits to those who have been completely isolated from others during this extended time of sheltering in place. In other instances, we've been able to offer support over the phone, over FaceTime, text, or email. Care is about reaching out to connect with one another, and that's what Arden Wood is all about. With this in mind, we are delighted to present these informational webinars, and we encourage you to invite a family member or friend to join us for future events. Please know that the information provided in these workshops is not intended to constitute legal advice. All content is for general informational purposes only. Now, let me introduce today's speaker, Edward Pearson. Ed has been practicing law for more than 40 years, and most of those years have been devoted to estate planning and estate administration. He knows what he's talking about. Ed chose one school to receive his undergraduate, JD, and MBA degrees, the University of Southern California, or USC. Ed is a Trojan through and through. Ed is a partner in Overton, Lyman and Prince, LLP, which claims to be LA's oldest law firm. It's been around since the late 1800s. He manages the firm. Ed has 2 wonderful adult daughters, one of whom is a lawyer and works with Ed, both of them from their respective homes during this pandemic. He also has 2 very little grandchildren, with another on his way in December. Ed is a big baseball fan, but he roots for the Dodgers, which is a shame for us Giants fans. Here's a fun fact about Ed. For years and years, he has been involved with the Pasadena Tournament of Roses, which organizes the Rose Parade on New Year's Day. Like so much of our usual activity, this too has been canceled for the upcoming New Year's Day. The hope is to come roaring back on January 1st, 2022. I can say if you've never been to the Rose Parade, I highly recommend it for your bucket list. Before I turn the program over to Ed, let me explain how you can ask questions. If you look at the bottom of your Zoom screen, you'll see an icon that says Q&A. Click on it, and a screen will appear where you can type in a question. Then press Submit, and it will arrive here. We will collect them and save them for the end of Ed's presentation, when he will answer as many as we have time for. We may also carry over some questions to Ed's second workshop next Thursday at the same time and on the same station. Please join me now in giving a warm welcome to Ed Pearson. Ed?
Thank you, John. You know, I'm very, very happy to do this. Talking about estate planning is something that I have done from time to time, and I hope that I can share some basic concepts with all of you today. We're certainly not going to be planning an estate during this workshop, but we're going to be getting some of the details and some of the vocabulary and things like that made available to you. The first thing I want to do is to make very clear at the start, I am a California lawyer. And if you are attending this online from another state, many of the things that I am going to be saying will not apply exactly to your situation. However, nearly every state will have counterparts to what we have here in California. One specific thing about California is that it is a community property state. At last count, I believe there are 8 throughout the country. But again, some of the concepts that apply for community property really are applicable in other states as well. Another thing I want to say in starting is that this really is not a seminar in living trusts. You're going to hear an awful lot about living trusts, and there's a good deal more to be said about them. But one of the things that I'm hopeful is that we can supply some context so that you know where a living trust fits in to the whole overall situation of estate planning. I wouldn't want to hazard a guess, but I would say that probably 75%, maybe 90% of the people that are listening to this would benefit from the use of a living trust, but it is not necessarily that every single person needs to have one. But maybe we can show you reasons why a trust makes sense. We're only going to be touching on some of the basics today, but if we can become familiar with the concepts, the vocabulary, when you do make an appointment with an estate planning lawyer in your jurisdiction, wherever it might be, you'll be able to explore this whole concept of estate planning a little more efficiently. There won't have to be quite so much in the way of, you know, catching up with what we're talking about. So let's move to the next slide. This shows the goals that I am hopeful we can, we're gonna hit the goals next. And I want to be, you know, sure that the overall intent of doing estate planning is to make sure that what you have, what you've accumulated, what you leave behind can be transferred to the persons or the institutions that you intend to receive it. And to make sure that that is done in such a way that it maximizes the speed, reduces or minimizes the expense, but also makes certain that we match the technique that we choose to the assets involved. We'll be getting into all of that as we go through this. Most of the time, there will be the need to select a fiduciary to run the show, the person that will be making sure that the assets get transferred to the appropriate persons and that the other steps that need to be taken are taken. And so that person is going to be a fiduciary. Sometimes that the title will be executor. Sometimes it will be trustee. We'll also get into the fact that this will sometimes be an agent under like a healthcare directive, which is not technically a financial document, but is one that is very much part and parcel of an estate plan that is usually prepared. And we want also to be sure that in deciding upon the right technique to use in terms of how we handle our property, we want to be sure that we're not exposing any of those assets to the claims of creditors, at least to the extent that we can. We want to be sure that you're not walking into a trap. As I see it, the lawyer's job is often to alert the client to what some of the pros and cons are of some contemplated action, so that the client goes into doing that action or taking that action fully informed with eyes wide open. Let's move to the next slide. As John mentioned, this is not necessarily a fun subject to think about what's going to happen to an estate after you're gone, but that is the orientation that you have to have in estate planning, is what do I have? How can I get it to the person or institutions that I want to receive it in the best way possible? Definitely in the course of this process, you will encounter lifetime issues, and we'll get into some of that too. But there is definitely what's going to happen after I'm gone orientation to the whole process of estate planning. And moreover, that orientation tends to be sort of a short-term horizon. You can't really be thinking about what's going to happen 30 or 40 years from now. Yes, that you'd be wonderful to think about that, but I can't think of how many times I've been in a conference with somebody and I use the old phrase about getting hit by a bus. I mean, I don't know how to say what has to be said sometimes, but you do have to think about what happens if this estate plan needs to be implemented in the near term. Some of the things that we're going to be talking about in terms of means to avoid probate, which is our next slide, is that we will have, there are some limitations to some of the techniques, and we need to be sure that we get into those. Just as an example, if you were to hold property in joint tenancy with another, joint tenancy property belongs to the survivor upon the death of one joint tenant. So if two people own property as joint tenants, it passes to the survivor, and that's all well and good, but then the survivor may face a probate unless he or she does something with the property. Moreover, what happens if both joint tenants die in some kind of common accident? Then you might have two probates, or potentially on half of the property for each. We're going to talk just very briefly about estate and gift tax. In today's world, we have very, very large exemptions. The exemption from the estate tax is very nearly $11.5 million for an individual. With the way in which the tax is structured now, that means for a married couple, a total exemption of about $23 million. Now, that's the way it is now, and what that has meant is that a lot of the old estate planning techniques, estate planning, or techniques to reduce estate tax are no longer needed. If you happen to be up there in the 11.5 million range, congratulations, and then you can do some of the fancy-dancy estate planning. But for the vast majority of us, estate tax is not an issue today. But tomorrow may be another story, and we're having an election very soon. We don't know what will happen to the estate tax depending on who wins. It is something that, while it's tempting to just kind of ignore it, it may be coming back to at least be something to get our attention. And I also want to refer back to a once upon a time, and that is not too long ago, these exemptions from estate tax were very much lower. And it was often the popular technique of the day. And I'm thinking now the 1980s, the 1990s, the early 2000s. You saw many married couples creating trusts, which were, there's a variety of titles were given to them, but very often the title given was an AB trust. And there are lots of trusts out there like that, that if people had to choose again, they probably would not be setting up that A and B division. We'll talk about that a little bit too. Something that is kind of an important concept in the estate planning field, and really relates to estate tax too, is that property, if a holder of property dies, that property receives a new income tax basis equal to its value at the time of death. You can see how that's quite important in connection with, let's say, California real property anyway, with property purchased years and years ago that has so significantly increased in value. I'll just give my own story. My parents bought a home in San Diego back in the mid-1960s for $24,500. Both my mom and dad died in the year 2005. And believe me, that property was worth one heck of a lot more than $24,500. If they had sold that property before their deaths, there would have been a significant capital gain. But because the property received a new basis equal to its value upon my mother's death, she was the first to go, the property received a new basis equal to its then value. It was sold shortly after my father died for the same amount as had been the appraisal at the time of my mother's death, meaning that zero capital gain was paid. It's an important concept and one to be explored when you are dealing with an estate planning situation. And finally, property tax. In California, we've got Prop 13, and one of the things that we are going to be facing in this California election are a couple of ballot propositions regarding some changes to Prop 13. But in terms of residential property values, the kinds of things we're talking about here, like creating a trust and so forth, will make no difference to residential, the same low property tax values that have always been the case. There will not be a change of ownership upon the creation of a living trust. We'll go to the next slide. And here we're talking about, you've heard the word already, probate. Well, what is it? Why do we talk about avoiding it? Probate's a court-supervised process of dealing with all of the repercussions, I guess you would call it, of the death of an individual. The court supervises the appointment of a representative, makes sure that that representative inventories the assets of the estate, determines who the appropriate distributees of that estate will be, make sure that creditors get paid. It's a process that takes some time. I think in general, you can count on probate taking about a year. I suppose there are some instances where it can be rushed through in maybe 8 months at a minimum. But more likely, you're talking somewhere between 10 and 14 months as a typical probate time. Those of you in other states might find that probate is a much quicker process than it is here in California. And by all means, explore that when you talk about whether probate should be, in fact, avoided. It's also expensive. Even if the executor of the estate were to waive any fees, the attorneys handling the estate typically will not. And those fees are based on a percentage of the estate. Just as an example, a $200,000 probate is a $7,000 attorney fee, and it goes up from there. So it can be a very expensive thing to do. So in light of that, there are lots of ways that have been developed through the years, not necessarily strictly to avoid probate, but they also happen to do that. And we're going to be talking about some of them. For instance, joint tenancy. I've already said something about that. It's the means by which two owners have what is referred to as right of survivorship. Whichever of two joint tenants or more, there can be 5 joint tenants. And upon the death of one, it belongs to the other 4. And then the 3, then the 2. But that's the thing that needs to be done. All that happens is a death certificate is presented. Let's say it's a bank account. 2 joint tenants are on the account. A death certificate is presented. The account is retitled in the name of the surviving joint tenant. Very, very similar is a pay on death arrangement. It's quite similar to naming a beneficiary, like of a life insurance policy. I've seen this used on investment accounts. I've seen it used on bank accounts, where you set it up so that upon death, the assets are transferred then to the designated beneficiary. You can see that in both of those situations, and really in number C there beneath that beneficiary designation, like with life insurance, one of the limitations is that the joint tenant that you might intend to receive this property may predecease you, the creator of the joint tenancy, the creator of the pay on death account. Or there could be the common disaster kind of situation. Moreover, if the individual who receives the asset then does not have a plan in place, there could be a probate for him or her, which, you know, is not something you can control, but it's at least something to be considered. There is in California, an amount under which property can pass without the full court proceeding. There's a way to transfer assets based on basically an affidavit. We call it a small estate set-aside procedure. The amount that can be transferred at this point, and it's been going up through the years, is now $166,250. If you've got an estate of $100,000 and you want it to go to a certain individual, you can write a will. That individual, upon your passing, can present certain documents to the bank and receive the account without probate. But with all of the limitations that we've discussed already and some more that exist, what many people find as the best solution is the creation of a living trust. And that's one of the things that is kind of the thing to do at this time. Again, there are exceptions to everything. It's not necessary that everyone have a living trust, but it is quite popular thing to do. I put down there disputes and contests. There are ways in which, if someone is disgruntled, someone does not like what you have put into a document, and if they have standing to protest that, they have the right to contest, let's say, a will or a trust. That might not be the case in connection with some of these other things like joint tenancy or pay on death, but it is nevertheless something that you have to keep in mind as a possibility. I had a lawyer mentor of mine who insisted that his estate go through probate. There are certain individuals who want to see that whole process overseen by a court. It just gave him a sense of security that his family was going to know that everything was done right. It also sometimes can give some finality to creditors. There are some limitations upon when creditors have to make claims against the estate. And if you go to probate, those timelines come into play, and a creditor might be required to file a claim more quickly than if property were held in some other form, such as a trust. I also write down here conservatorship, lifetime probate. This is one of the other reasons why people create trusts. If someone is disabled and can no longer handle their affairs, it may be necessary to have a court supervise the administration of that individual's financial and personal affairs. And that's done through a process referred to as a conservatorship. This is a guardianship for adults, and it may well be referred to as a guardianship in other states. So the use of a trust is one of the ways in which a conservatorship can be avoided. If all of the assets are held in a trust, it won't be necessary to have a conservatorship over the estate of this disabled individuals. All right, we'll move on to the next slide. And I titled this as variables. The point that I want to emphasize here is that there is no such thing as a one-size-fits-all estate plan. We're all in unique situations. Yes, if you took a look at the different trusts that I prepared, you would see that most of them on the surface appear to be very, very similar. And indeed they are. They are based on forms. All of us use settled forms that we have used for some period of time. We know what they say. We're comfortable with them. We only have to update them occasionally when the law changes. And they're full of boilerplate, those pages and pages of legalese. But underneath all of the surface, there are changes and there are differences between those trusts. And those differences exist because people are different and people are unique. So the family situation of person A is going to be different from that of person B. The dynamics of the family of person C are very different from those others. You may have young beneficiaries. You may have old beneficiaries. You may have beneficiaries that have special needs. You may be a person with children, or you may be a person or a family without children. All those things are going to impact the way your estate plan is prepared. And moreover, you may have different philosophies than someone else. You may believe that children, if that's who we're talking about as beneficiaries, should receive their estates as soon as they can, when they're very young. Others have an idea that children are not terribly mature and their property needs to be held back from distribution until they have reached some age at which they are presumed to be mature. For some of you, charity is a vital element of your estate plan, and making sure that an institution receives some of your wealth at your passing as opposed to individuals. And so keep in mind Arden Wood. And we'll move to the next slide. What I have listed here in quotations is estate. I just want to highlight the fact that there are many, many different kinds of property. I mentioned earlier about how estate tax exemptions have increased so greatly. Back when I was a younger lawyer, there were lots of the states that did have to face the estate tax, and you kind of get mentally, you train yourself. What are the schedules to an estate tax return? And they're just what you see there, A and B and C and so forth. So that's why I listed those. They're not exactly in the right order, because it used to be that the B would be the stocks and bonds, and C would be bank accounts. I flip-flop them. But in any event, what you're going to be doing is eventually, we'll get to the planning in just a minute, trying to take stock of what you've got, trying to take inventory. And you need to do a real examination of everything that you have to make sure that you have everything listed in order to go through this process. One of the things that I put down there is powers of appointment. And I also put down the heading of tax definition. There are things that you may not consider something you own. It's something that someone else left for you, perhaps in a trust, and you receive the income from it. Well, it's also possible that within that trust, the creator of the trust gave you a power of appointment, a power to decide who would receive that principal after you were gone. That power of appointment may or may not, depending on the extent of the power, constitute your property for purposes of estate tax. And while exemptions are very, very large now, and it may not matter quite like it did once, you still need to realize that that is part of the assets over which you have control. Life insurance is similar. Years ago, when estate tax limits or estate tax exemptions were smaller, the idea was that sometimes we could take life insurance out of the taxable estate. There were various techniques to be able to do that. And in order to make sure that the life insurance was not counted as part of one's estate, you had to be sure that the individual, the insured person, did not have the so-called incidents of ownership, such as the ability to change beneficiaries, things like that. And I know that's rather technical, but it's just a way of alerting us to the fact that property comes in a lot of shapes and sizes, and you need to look for it. All right, let's go to the next slide. And we're going to talk about this planning process. And I call the part of it as getting started. This is the first part, and the next slide. Can we move to the next one? Yeah. All right. The process of getting started is really a matter of information gathering and information sharing. Commonly, I wouldn't say every time I start an estate planning representation, I send out a questionnaire. But it is a way of accumulating information. If nothing else, then just to be sure I get the spellings right and the names of the children down or whatever it may be. So I send out a questionnaire, but it's really, as I say, just a way of gathering information, and you can do it yourself. Take inventory. Take inventory of where your assets are, what assets you hold and how they are held, if between spouses or in joint tenancy with another. All of this information is going to be very useful to the estate planner when it comes time to go ahead and put something down on paper. I listed there, one of the ways of holding title is just possession. Really, this applies more so than anything else to things. The fact that you have a bicycle or your old surfboard or whatever it may be in the garage, there's no title to that asset, but it's yours, and you need to write that down, maybe not each individual item, but the category of tangible items, so that there can be, it will prompt a question from the estate planner when you have a conference. That conference, by the way, up until 6-7 months ago was an in-person conference, and more it's a Zoom conference, but I think we're all getting used to it, and it's, you know, we're making do, let's put it that way. And after you take stock, after you make this inventory, the question comes up, will my estate need a probate? As part of taking inventory, you're probably going to be listing things and may determine that you already have something in place. You hold something in joint tenancy with another. You have a community property asset. Again, that's just spouses and that's just California. So there are lots of different things that you will be finding out, but you'll also be looking at values. And that's where the significance of that 166,250 comes in. You'll have to, as part of your inventory, determine whether you have in existence any kind of a document already that needs perhaps to be updated. Have you written a will in which you say, so-and-so gets my surfboard when I die? As John mentioned, there are people that die without a plan, and that's referred to as intestacy. And the different laws of the different states will, in effect, determine where things are going to go. It's, for lack of a better phrase, the state writes your will for you. And it's what you might expect. The first property goes to spouse. The second, the next in line would be children, grandchildren, and then you might go off to the side of the tree, brothers and sisters, nieces and nephews. So it's just something to be aware of. Intestacy is not necessarily a terrible thing, but it is not something that you want either. All right, let's move to the next slide, which is part of the next phase of this, and that's making a plan. I want to be sure we're doing okay time-wise. We look good. There will be different kinds of considerations for what to do if you're a single person than there would be if you are part of a married couple. In the case of a married couple, there will occasionally be, and again, speaking as a California attorney, there will occasionally be times when you would have separate trusts for husband and wife. That's rare. Nearly all the time, it's a joint trust. It's the John and Mary Smith Living Trust, or whatever it might be called. I mentioned the AB arrangement that was sort of a tax-driven division at the first death, where one spouse died, the trust would be divided into two parts. The A trust representing the 1/2 of the property. We're making the assumption it's all community. The 1/2 of the property belonging to the surviving spouse, and the B trust containing the 1/2 of the community property belonging to the deceased spouse. Well, as I mentioned, that kind of AB division has gone by the board in terms of a division that's motivated by taxes. We don't need to do that anymore. There are nevertheless many married couples that do want to divide the trust at the first death, because what happens in that situation is that the B trust, the one of the deceased spouse's share, will go to the intended beneficiaries of the couple upon the death of the survivor. The B trust is held for the survivor's benefit. He or she can make use of it. But the idea is that the survivor cannot divert the B trust away from, let's say, the children in favor of perhaps a new spouse. The division at the first death is more rare today, but there are instances where people are concerned about that. My spouse is going to remarry and give everything to the new spouse. I don't want that to happen. I want my half to go to the kids. It's more common and more useful, frankly, in the event of second marriages, children from, they're children of spouse, the husband, children of the wife. The idea of an A and B division under those circumstances is a little more frequent. So in making the plan, you evaluate based on the information that you've accumulated. What are some of the other probate avoidance techniques that are available? Should we use them? Let's take a look at that. To the extent that we do not use other avoidance techniques, probate avoidance techniques, is a will sufficient? Is it not? Do we need to create a trust? Do we have some combination? In other words, joint tenancy as to certain assets, transfer on death as to others, other things in the trust. I list here what is a very common estate plan structure. And this would be when making a plan, it's determined that a trust is the right way to go. The trust, of course, is the primary document, and that will be the most important. The centerpiece of the estate plan is the way I would refer to it. But you still have a will, because in creating the trust, you may or may not be putting all of your assets into it. And again, thinking of typical situations that I have faced, I will tell people, no, it's not necessary to put that $3,000 bank account, the one that has your, that you use to pay the light bill. You can put it in the trust, but you don't have to. It's not critical getting back to that $166,000 figure. If all the other assets are in the trust, the $3,000 bank account can pass without probate because of that $166,000 amount. An estate plan will probably include a power of attorney for assets. This is something that's a lifetime document as opposed to one that carries on after death, but it nevertheless is quite frequently part of the package. So is an advanced healthcare directive. And in this day and age, it's quite important that you make such a document. There are lots of resources in order to create one. One that I have used very frequently is one that's created by the California Medical Association. But I know that there are, I'm sure that Arden Wood has on its website some sort of an advanced directive, and it is available to state what a Christian Scientist would want done in terms of health decisions and health care in the event that he or she were disabled or unable to make decisions for himself or herself. Also part of the estate plan would be the funding documents. When you create the trust, and let's say you're an owner of real property, you're going to make a deed by which the property is taken out of your individual name and put into your name as trustee. And by the way, in almost all these situations, it is you are your own trustee, at least initially. There are other assets, insurance comes to mind, retirement accounts come to mind, where you need to be sure that your beneficiary designations are up to date and correct. And so that will be part of the discussion that one has with an estate planning attorney. And if you are a parent of minor children, you need to be sure that you have designated someone to take care of those kids, and a nomination of guardian would be the appropriate way to do that. So we're going to talk next about, just briefly, I think we have a couple more minutes we can talk before we go on to questions, and then we'll be able to wrap this up next time. So let's move to the trust as the next slide. I indicate here, and this is really, if I am sending out, again, this is my technique. Other lawyers, I'm sure, do it differently, but I will send somebody a questionnaire, and I'll say, here are, things that I need this information, make sure I get the spellings right, that kind of thing. But I also, in my email, will say, here are the things that we are going to cover in our meeting. And all the time, every single time, there will be these three basic considerations for all of the trusts that I do, no matter whether it's a single person, married couple, whatever it is. The first one is, your trust is a will substitute. It does what a will does. It takes your property and gets it to the intended persons after you're gone. So consideration number one, to whom and how shall the trust assets be distributed? Is it going to go equally to the children? Is it going to go to your brother? Is it going to go half to the wife's sister and half to the husband's brother? These kinds of things. And if we're talking about perhaps children, do you want it to go to them immediately, or only when they get to be age 30, or only when they get to be age 45, or frankly, never? You know, is it always going to be income to them? So that's consideration number A. B, who's going to be in charge? Who's going to run this show after you're gone? Now, the technical name for that individual is the trustee, but in common everyday language, that's your executor. The executor is technically the person named in a will to handle an estate, but it's sort of shorthand for, it's what people will usually refer to as the one that's going to make certain that assets get from point A to point B. And then the third consideration is, what are your assets? Which ones are we going to have to transfer to the trust? Do you own a residence? We're going to need the deed to that so that we can prepare a new deed. Where are your investment assets? Do you have retirement accounts? Do you have significant cash balances in banks? Do you have that $3,000 bank account that you use to pay the light bill? Those kinds of things. Now, if we go to the next slide, after we get through those basic every time questions, we'll have some, I guess you would call it more specific questions. In the case of a married couple, do we have to determine whether or not the trust is going to divide at the first death, the thing we talked about a couple minutes ago? Do you have specific gifts of property that you want to make? The blue lamp to Aunt Edna, or $10,000 to, let's just say, Arden Wood? Are you going to be making specific gifts in your trust? Are you going to be treating people that might appear to be equal unequally? Is it going to be the shares for my son and daughter are going to go outright to them, but the share of my young son is going to be held in trust for him? Do you need to write in disinheritance provisions, no contest provisions? There are a lot of things that we can get into, but the point is there are a lot of things that are going to be discussed during this conference. I put down there younger beneficiaries. What is, it's again a common thing. Everything to my kids. If any of my kids predeceases me, it goes to his kids or her kids. Well, those grandchildren of yours might be 12 or 16 or something like that. How do you want to treat them? What I wrote down there is CUTMA, which stands for California Uniform Transfers to Minors Act. A uniform act, by the way, is one that is not necessarily in all 50 US states, but in many of them. It's a uniform act that is designed to be something that would be relatively or approximately the same throughout the country. And with a CUTMA account, you can say it's going to go to a custodian to hold for the individual until they hit 18 or 21 or potentially 25. If you want it to go to later ages, so the grandchild in our example won't receive it until age 30, then you'll have to leave it in trust to make that happen. You may have a spendthrift situation where you need to worry about, somebody receiving principal ever. And those are the kinds of things to discuss. And finally, I put down here the catastrophe provision. What happens if your whole family gets wiped out? Husband, wife, 3 kids. What is to be done then with the assets? And there's the fallback of it goes to whoever your heirs might be, parents, siblings, nieces and nephews, or it could go to some institution. So it's, even though the likelihood becomes lesser and lesser, nevertheless, it's important that you have that as part of your trust. So what we've done so far is to run through up to the point of talking about who might make a good trustee, which is officially the subject of our session for next time. And I'm going to skip over the section, that part for a minute. I want to talk just for a couple minutes before we go to questions about the estate planning pitfalls, and I call them no-nos, as the next slide. Hypothetical number 1 is, what happens if you create this wonderful trust, but you don't get your assets into it, and you also perhaps don't have a pour-over will to make sure that your assets end up in the trust. The hypothetical here, and we'll move a couple of slides ahead to where the cats are. There we go. I have to say that my cat-loving daughter is the one that wrote the hypothetical. So anyway, so Jane Smith owns a house in her name and a bank account with $500,000. She creates the Jane Smith Trust and names as the beneficiary of the trust her favorite charity, Cats and Art, Inc. She forgets to execute a pour-over will, never makes a will of any kind. Jane never takes any steps to put her house into the trust, doesn't put her bank account into the trust, and these assets continue to be held in her individual name. When Jane dies, her estranged daughter turns up and claims the house and the bank account as Jane's intestate heir. Cats and Art Inc. is prepared to fight, but they realize that the house and bank account are not trust assets, and therefore there is almost nothing they can do. They might try, and there are perhaps some means by which they can make a claim, but it's going to be tough. So these are things to, the other 2 hypotheticals are along the same line, but I think what we'll do now, and we'll pick up with those hypotheticals the next time, and also discuss a little bit more completely the matter of naming the trustee. I think the idea was that, perhaps this first session would really be like almost 1.5. So we'll use the first part of the next session to go through the other hypotheticals, talk about a couple of other things, and then use the next part of the next session to talk about naming a fiduciary. And in terms of naming a fiduciary, we're not just talking about trustee, we're also talking about such things as an agent under an advance directive. So we'll get to that next time around, and we'll hope that we have some questions from you to be able to spend a few minutes before we call it an evening. All right, now I'm going to I think I bring John back in.
Thank you, Ed. Before we go to questions, and we do encourage you to send them in now, we'd like to take a quick poll. The poll will pop up on the screen. Please click on your answer and hit submit. All answers are anonymous. We'll let you know the results. So please take a moment now. While you're polling, I do want to mention that, as Ed mentioned, we do have an advanced healthcare directive on our website at ardenwood.org. Again, this is for California, but these can be easily adapted and it gets you started. I can say, at least in the care business that we are in here at Arden Wood, you must have an advanced healthcare directive, and it's the loving and appropriate thing to do. If you're not able to speak for yourself, you want to make sure that you have your wishes carried out, and that that is stated, because otherwise they will not be carried out. They will be, you will go the direction that people feel you should go, that may be counter to your wishes. Do we have the results of the poll? Is this the time to do that, or?
70% have responded.
70% have responded. Okay. So looks as though people have checked their estate 1 year ago is at 13 or 25%. Between the last 5 to 10 years is 27%. 10 or more years is 14%. And the 33%, do not have an estate plan. For those in the last category, that's very common. And that's why we felt it's so important to have a plan, because that is typical. I think the rule is about 50% of all Americans do not have an estate plan. It's so important. We do have one question up front, and I think we've got another question coming in. Ed, what is the percentage of attorney fees for probate in the state of California?
Well, it is a declining percent. It starts at 4% of the first $100,000 of estate, 3% of the next 100,000, 2% of the next 800,000, 1%, I forget exactly where 1% goes, like to 5 million or something like that. And then it eventually does go to 0.5%. But I think one way to look at that is that $1 million probate generates an attorney fee of $23,000.
Wonderful, thank you. I have another question.
Mm-hmm.
If a husband has the same amount in his IRA as in the trust and wants to give all that money to charities, is that normal?
I'm not exactly sure what is meant by has the same amount as in the trust. But I don't know that there's anything that I would call normal. I think that charities can certainly make use of IRA money, because the fact is that money that's held in a retirement account of some kind, IRA particularly, it's all going to get taxed when it comes out. Under the newest law, what was that, 2019, it is less possible to defer the recognition of income in an IRA than it used to be. It still is possible in the case of a spouse, but in case of other beneficiaries, you're going to be, it's going to be required that you recognize the income more quickly, which means taking the money out more quickly. With money available for charity, there isn't any such worry about the income tax aspect of it. The charity is not going to have to pay any income tax on that money.
Thank you.
But by the way, I should say that, I'm not certainly an expert in the taxation of retirement accounts. I know something about it, but not as much as I should, perhaps.
Thank you. Another question. What effect will the filing of ROE, or revocation of election, to pay taxes have on the estate and beneficiaries? The effect when the beneficiary files an ROE.
Can I be really honest? I don't know what an ROE is. I suspect it does refer perhaps to retirement type accounts. I do not know.
Okay, I've not heard that term either, so that's helpful. Another question. Can charities or Arden Wood accept foreign currency as a gift?
I expect, John, you might know more than I. I don't
Yes.
see why not.
I will say yes. Thank you for that. And of course, and I just want to make one statement this is a personal statement. As I say, as we're a nonprofit, of course we want support for Arden Wood. That's my job. That's our job, to make sure that the Arden Wood mission continues. But I have a very personal feeling about the importance of planning. I have seen people that don't plan destroy families, or there are so many ways that we can avoid trouble after we pass so that harmony can exist. We can have our assets go to the charities or the people or organizations we want them to go to, and avoid so much turmoil. So anyway, I just put that personal statement in there. Next question. I'm a widow with no children. My siblings and family have passed on. Charity is large in my estate planning. Are there considerations I should keep in mind?
I think primarily to be certain that that you yourself are taken care of for as long as you need to be. Yes, charity is wonderful, but by all means make sure that you have enough to take care of yourself before making any kind of gifts to charity during lifetime. But in terms of a post-death disposition of your estate, I think you could do so by means of a will. You could do so through a trust. If there is, this might be the kind of situation where a transfer on death kind of account might be just right. Depends a little bit on how the assets are held. Let's just say that it's an investment account. Lots of, stocks and bonds in some sort of an investment portfolio. You could make that a transfer on death account to your favorite charity. So it does depend a little bit on just what the nature of the assets are. But I think the primary thing is just to be sure that there's an amount that is available to you, and then to make sure that there are the transfer devices in place to get your assets to one or more charities.
Thank you all for joining us. I think that seems like a good time to close. We've just gone over the hour. Thank you all for joining us today, and thank you, Ed. That was very helpful. And a good reminder for all to set up or review your estate plan. Now is the time. I love acrostics, and mine for plan is prayerful listening, acting now. Ed will be back next Thursday at 4 p.m. Pacific, and we'll pick up where we left off. Please feel free to invite a friend to join us. As you know, it's easy to register on our website. Bye for now. Thank you all.
Thanks.
Thank you, Ed.
All right.